As we begin to evaluate the lawsuit Draya Howard has filed against Tyrod Taylor, here are a few legal concepts that you should keep in mind. In California, the statute of frauds is a legal doctrine that requires certain types of contracts to be in writing to be enforceable. This includes contracts for the sale of real estate or leases that are longer than 1 year. The relevant statute is found in the California Civil Code section 1624. As you can see, California Code, Civil Code, section 1624A says, the following contracts are invalid unless they or some note or memorandum thereof are in writing and subscribed by the party to be charged or by the party's agent. 3. An agreement for the leasing for a longer period than 1 year, or for the sale of real property, or of an interest therein. Such an agreement, if made by an agent of the party sought to be charged, is invalid unless the authority of the agent is in writing, subscribed by the party sought to be charged. Keep this in mind as you listen to this reading of Draya's lawsuit. The suit starts with a bit of dry legalese, but then gets into the allegations, so be sure to listen to the end. Come now, plaintiff Draya Howard, Miss Howard, an individual, and alleges as follows. The parties 1. Miss Howard resides, and at all relevant times resided, at real property located at Chatsworth, CA 91311, the property. 2. At all relevant times, the property belonged to defendant Zaltana Street, LLC, the LLC, which defendant Tyrod Taylor, Mr. Taylor, is the sole member of. A true and correct copy of LLC's 2024 Florida Limited Liability Company Annual Report is attached as Exhibit A. A true and correct copy of the deed for the property is attached as Exhibit B. 3. Ms. Howard is unaware of the true names, capacities, and identities, whether individual, corporate, or otherwise, of DOE defendants 1 through 20, inclusive. Ms. Howard therefore sues these defendants, and each of them by fictitious names. Ms. Howard alleges on information and belief that each of the DOE defendants is responsible in some manner for the occurrences alleged and proximately caused or contributed to the injuries and damages alleged. Ms. Howard will amend this complaint to state the true names, identities, and capacities of such fictitiously named defendants when the same have been determined. For each of identification, all references to any defendant shall also refer to does 1 through 20, inclusive. 4. Ms. Howard alleges on information and belief that defendant and DOE defendants 1 through 20, inclusive in each of them, are or were at all times mentioned herein defendants' ego, agent, servant, representative, or employees, and were responsible in some manner for the events referred to herein. The acts and omissions alleged herein were done by them, acting individually, through such capacity and within the course and scope of that agency and employee, with defendant's permission and consent. Jurisdiction and venue. 5. Jurisdiction is proper in the Superior Court for the County of Los Angeles, pursuant to Code of Civil Procedure, Section 410.10, because the court has general subject matter jurisdiction, and no statutory exception exists. The amount in controversy exceeds the jurisdictional minimum of this court. 6. This court has personal jurisdiction over the defendants pursuant to Code of Civil Procedure, Section 395, because the contract was entered into in the County of Los Angeles. 7. Venue is proper in this court because this case involves rights and interests concerning real property, the property located in the County of Los Angeles. Background allegations. 8. On or about August 12, 2022, Mr. Taylor, LLC, purchased the property for Ms. Howard to take residency with her children. Ms. Howard and Mr. Taylor were in a romantic relationship, and Mr. Taylor promised that any contributions she made towards either improving or satisfying the mortgage of the property will be applied towards the purchase value of the property when she decides she wishes to transfer title. 9. On or about October 23, 2023, Ms. Howard and Mr. Taylor memorialized the terms of their oral agreement by drafting a residential lease agreement with an option to buy agreement, collectively the memorialization. The memorialization provided that any payments that Ms. Howard made towards the property would be credited towards her down payment should she exercise the option to purchase the property anytime between November 2023 through October 31st, 2025. It also stated that Miss Howard's first payment will become consideration for the right to exercise the option to purchase the property. A true and correct copy of the memorialization is attached as Exhibit C and Exhibit D. 10. The memorialization was not signed by either party, but verbally and by conduct acknowledged by both. The lack of formality stemmed from the fact that Miss Howard and Mr. Taylor were in an intimate relationship at the time of contract formation. Moreover, Miss Howard made substantial improvements in payments to the defendants in reliance on Mr. Taylor's promise that she would acquire ownership over the property and that she reserved the right to exercise this option anytime before October 31st, 2025. 11. On or about October 23rd, 2023, Miss Howard also prepared and sent the defendants a purchase agreement, the purchase agreement offering to purchase the property for approximately $2.8 million with the escrow closing on October 31st, 2025. A true and correct copy of the purchase agreement is attached as Exhibit E. 12. On or about November 7, 2023, Mr. Taylor counteroffered through his realtor agent that he wanted immediate proof of funds or a mortgage approval letter from a lender to substantiate Miss Howard's ability to purchase the property. They also demanded that she pay $19,813 per month for the remainder of her stay on the property. And finally, they promised she could purchase the property for approximately $3.2 million, more specifically, $3,209,723.06, which includes the deduction for 2 rental payments Miss Howard had made and the 6% discount as stated in the counteroffer. In the completion of the purchase, to happen at a reasonable time that is agreeable to all. Additionally, Mr. Taylor promised that any other financial contributions that Miss Howard made towards the property would be credited towards the purchase value of the property. 13. On or about January 12, 2024, Miss Howard accepted the defendant's offer by providing them with a mortgage pre-approval letter. She also accepted purchasing the property for approximately $3.2 million and agreed to paying $19,813 per month, provided it would be deducted from the final purchase price, as they had originally agreed, formalizing the final contract, the contract. She further informed them that between September 2023 and January 2024, she had spent a total of $270,000 in improving the property, which also needed to be deducted from the final sale price. 14. Howard continued to perform her duties under the contract by paying the agreed-upon lease payments with the understanding they would be applied to the final purchase price, which the defendants accepted. 15. Moreover, the improvements she made to the property not only increased the value of the property, but embodied her stylistic preferences, truly making the property unique to her. Surprisingly, defendants are now threatening to evict Miss Howard from the property, where she currently resides with her 3 minor children. Furthermore, they are refusing to sell the property to her, despite the substantial improvements she has invested in the property, believing in good faith she would eventually own the property, and thereby unjustly benefiting the defendants. First cause of action, breach of contract against defendant, LLC. 16. Miss Howard incorporates by reference all the allegations set forth above as though fully set forth in this cause of action. 17. Miss Howard accepted the defendant's counteroffer to sell her the property for $3,209,723.06, an adequate consideration $19,813 when monthly payments were exchanged. Miss Howard performed her duties under the contract by paying rent to the LLC and making significant improvements to the property with the understanding that she will eventually own the property and any financial contributions would be deducted from the $3.2 million sale price. The defendants in turn accepted the monthly payments per the agreement. 18. The LLC breached the contract by refusing to sell her the property as agreed and caused emotional distress by threatening to evict her even after she complied with their request to provide them with proof that she was able to purchase the property and covering the defendant's mortgage with her monthly payments of $19,813. 19. As a result of defendant's breach, Miss Howard was forced to do a hard credit check to acquire a pre-approval for mortgage from her lender, negatively impacting her credit score, even though she was promised she had until 2025 to exercise her option to purchase the property. She was also lured into making mortgage payments on behalf of the LLC and expended substantial resources improving the property under the false pretense that she would eventually own the property. 20. Therefore, Ms. Howard is entitled to damages in an amount to be determined at trial. Second cause of action, breach of implied in fact contract and/or part oral and part implied contract against defendant, LLC. 21. Ms. Howard incorporates by reference all the allegations set forth above as though fully set forth in this cause of action. 22. Ms. Howard not only paid rent to the LLC, but significantly improved the property in reliance on defendant's promise that she would eventually acquire ownership over the property. Mr. Taylor also demanded that Ms. Howard provide hard proof from an approved lender and/or her financial statement that she had the ability to acquire the property when she exercised her option to purchase. The conduct and communication between the parties support the existence of a binding contract, and the material terms are sufficiently and expressly fleshed out. 23. That contract was breached when the LLC refused to sell the property to Ms. Howard despite her performance and exercise of her purchase option. Consequently, the LLC has been unjustly enriched since the mutual understanding between the parties was that any contribution Ms. Howard made towards the property would be deducted from its purchase value, and her contributions significantly increased the value of the property. 24. Therefore, Ms. Howard is entitled to damages in an amount to be determined at trial. Third cause of action, specific performance of contract against the LLC. 25. Ms. Howard incorporates by reference all the allegations set forth above as though fully set forth in this cause of action. 26. At the time that the contract was entered into, the parties mutually understood that Ms. Howard reserved the option to purchase the property until year 2025. Ms. Howard has exercised this option within the prescribed time. She even provided proof of financial capacity to the defendants that she would be able to purchase this property. 27. Furthermore, she regularly made payments to the LLC pursuant to the contract and significantly improved the property in reliance on Mr. Taylor's promise that all financial contributions would be applied towards the purchase of the property. 28. Therefore, the LLC breached the contract by refusing to convey the property to Ms. Howard under the original terms and threatening to evict her. 29. Monetary damages are insufficient to compensate Ms. Howard since she already resides in this property with her children, and it has become her primary residence. Any move would be detrimental to Ms. Howard and impose on undue hardship on her minor children. Furthermore, if each and every real properties were considered unique and distinguished, the improvements Ms. Howard has made to the property truly reflects her personal style, which makes it even more irreplaceable and exclusive. 30. Therefore, the only adequate remedy at law is to enforce the provisions of the contract, and plaintiff is entitled to specific performance by court decree ordering defendant, LLC, to convey the property to Ms. Howard in accordance with the terms of the contract. Fourth cause of action, breach of implied covenant of good faith and fair dealing against defendant, LLC. 31. Ms. Howard incorporates by reference all the allegations set forth above as though fully set forth in this cause of action. 32. Ms. Howard and the defendant, LLC, entered into a contract whereby Ms. Howard would lease and eventually own the property with the mutual understanding that any contributions made would be deducted from its purchase value when the title is transferred. Ms. Howard performed under the contract by paying rent and making substantial improvements to the property. 33. The LLC breached the implied covenant of good faith and fair dealing by refusing to sell the property to Ms. Howard when she exercised the option to purchase and accepted their offer to purchase the property for $3,209,723.06. This is particularly egregious considering the property had significantly increased in value due to improvements she made. 34. Moreover, Ms. Howard is a tenant amenable to all statutory and common law tenant rights. The LLC further breached the implied covenant of good faith and fair dealing by threatening to evict Ms. Howard when she was paying rent in a lease-to-own arrangement. 35. Consequently, Miss Howard was lured into making full mortgage payments on behalf of the LLC, in addition to making significant improvements to the property when defendants had no intent of selling her the property. Accordingly, Miss Howard is entitled to damages in an amount to be determined at trial. Fifth cause of action, promissory estoppel against defendant Tyrod Taylor. 36. Miss Howard incorporates by reference all the allegations set forth above as though fully set forth in this cause of action. 37. Miss Howard and Mr. Taylor were in an intimate relationship at the time the contract was entered into between the parties. Consequently, Mr. Taylor was not only Miss Howard's boyfriend, but her landlord. Mr. Taylor promised Miss Howard, even though the property currently belonged to the LLC at the time, she would eventually own it. Moreover, any improvements and rental payments she made towards the property would be fully deducted from the purchase price. 38. Relying on Mr. Taylor's promise, Miss Howard moved into the property with her minor children, significantly improved the property, and contributed to the LLC's mortgage payment on the property in the form of rental payments. 39. When Miss Howard exercised the option to purchase the property and accepted the final purchase value of $3,209,723.06 pursuant to the defendant's offer, Mr. Taylor, who is the sole member of the LLC, refused to sell the property to her even while the LLC continued to accept rent and consideration from her. Moreover, the defendants maliciously threatened to evict her from the property. 40. Miss Howard was deceived into making improvements and paying the mortgage on a property that defendants knew she was neither going to own nor benefit from any appreciation. 41. Therefore, Miss Howard is entitled to damages in an amount to be determined at trial. Sixth cause of action, unjust enrichment against all defendants. 42. Miss Howard incorporates by reference all the allegations set forth above as though fully set forth in this cause of action. 43. Miss Howard regularly paid rent and made significant improvements to the property based on a promise that she would eventually own the property. The defendants maliciously refused to honor Miss Howard's exercise of the option to purchase the property. 44. Miss Howard's financial contribution have increased the value of the property, inequitably benefiting the defendants. 45. Miss Howard is not only entitled to the sum of all contributions she made towards the property, as well as the appreciation in value to the property, in an amount to be determined at trial. Seventh cause of action, declaratory relief against all parties. 46. Miss Howard incorporates by reference all the allegations set forth above as though fully set forth in this cause of action. 47. An actual controversy has arisen and now exists between Miss Howard and the defendants as to their respective rights and obligations with regards to the contract. 48. Miss Howard alleges that a valid contract exists between the parties, and the LLC has breached the contract by refusing to sell the property to her under the terms of the mutual agreement, despite having substantially performed her duties. 49. Miss Howard desires a judicial determination of the rights and duties between herself, defendant LLC, and defendant Taylor, and their obligations under the contract in California law as to the lease agreement, purchase agreement, and option to purchase agreement. Prayer, wherefore, Miss Howard prays for judgment or relief against all defendants, and each of them, jointly and severally, as follows. 50. For damages in an amount as proven at trial. 51. For relief requiring defendant to specifically perform on the contract. 52. For plaintiff's emotional distress and mental anguish. 53. For an attachment of lien against the property in favor of plaintiff. 54. For a declaration that defendant has an obligation to sell the property to plaintiff. 55. For attorney's fees and costs incurred in this action. 56. For other such relief as the court deems just and proper. Plaintiff hereby respectfully requests a trial by jury on all appropriate issues raised in this complaint.